LSK.
Thank you, Commissioner.
Good afternoon, Felix Kosi, representing the public.
Thank you.
Good afternoon. My name is Mohamed Warsame, Judge of Appeal. Welcome.
Thank you, Your Lordship.
Good afternoon. My name is Olive Mugenda, Commissioner.
Thank you, Commissioner.
Good afternoon, my lady. Tehara Kariuki, the Attorney General.
Thank you, my Lord.
Good afternoon. I'm Anna Madi, Secretary JC.
Thank you.
Yes, thank you for that introduction. We will now start the interview with you telling us your county.
Thank you, Honorable Chief Justice. My county is Nairobi.
And your ethnicity?
In the form that I have filled, my lady, I have written other. I belong to the 43rd tribe of this country that cannot be placed amongst the 42 tribes. I am of mixed heritage.
Okay. Yes. You know why we ask those questions?
Yes, Honorable Chief Justice, I understand because I have been part and parcel of the transformation and the reform agenda in the country. So I really appreciate those questions.
Yes, you participated in the making of the Constitution, so that's where it all started.
That is so, my lady.
Yes, so you briefly tell us about your background, your academic, professional, and work experience, making some key highlights of the achievements that you have made along the way, and the skills and the values you think you are bringing to this position of the Judge of Appeal. But before you do that, I think it is important for me also to declare that I know you for many years, since we were practicing and since we were members of FINDA and since you are learning or founded the Muslim Sisters Association that worked very hard to bring the Muslim women to highlight them and ensure that they also get recognized and they get into positions of leadership. I think you are the author of this Muslim Woman, whatever the name Muslim Woman features because of the Muslim sisters. So I have to make that declaration that I know you as a friend and a professional colleague of many years.
Thank you. Thank you, my lady. I was admitted to the bar in 1987, so that makes me a lawyer of 35 years standing today. I practiced law for 23 years before joining the bench, and I was an all-rounder when I practiced as an advocate. I did civil, family, commercial matters, and as you rightly said, I was in the agitation for reform, and I did a lot of public litigation that dealt with the issues of women, children, and the vulnerable. During my stint as a lawyer, apart from practicing, I was part of civil society driven by the women's agenda, and more particularly because at some point I felt that I was doubly marginalized, being a woman and also coming from a minority community in Kenya. So I joined FIDA. I was a founder member of FIDA and was a council member and did a lot of litigation, which propelled me to be recognized by my community. And when the clamor for reform came up, I was approached by the Supreme Council of Kenya Muslim to form a network of Muslim women, and hence the birth of the Muslim Sisters Network. And I joined the reform under that banner and was embraced by the Kenya Women Political Caucus that was at the forefront in the agenda for reform. I thereafter joined the Ufungamano Initiative, which was a popular Mwananchi initiative that agitated for reforms alongside the opposition and the religious community. I was also quite at the forefront in bringing peace between the Ufungamano Initiative and joining the government initiative, CKRC, because I was a vice chair as a commissioner, a people's commissioner in Ufungamano. I joined the Constitution of Kenya Review Commission as a vice chair, having been recognized for my leadership skills at Ufungamano, and worked in that capacity for about 3 years, and eventually became the chair of the Constitution of Kenya Review Commission for 1.5 years. And I'm proud to say that I was able to lead the first ever referendum in this country successfully. The results may not have been what Kenyans aspired, because at that point the constitution was rejected, but the process was peaceful and successful. I was able to use my leadership skills to steer the process, to bring the country together, and give space for the competing interests. Thereafter, I went back into practice until when I was appointed as a judge of the High Court in 2009. I served in Nairobi in the Civil Division. Thereafter, I served in Kisumu and became the presiding judge of Kisumu, where I made a couple of changes in the registry. I ensured that we had a robust bar bench and a very active association for magistrates and judges. After that, I had a stint at Bungoma, and I'm proud to say that I left Bungoma a very good station. When I was posted there, it wasn't a very good station in the sense that quite often lawyers had a brush with the judges who were there, but due to my skills coupled with my colleague, the late Justice Mukunya, we had a vibrant bar bench relationship, and we were able to tackle the issues that bedeviled that station, which I must say was lack of communication, and also lawyers feeling that the place was understaffed and work was not ongoing. I was able to put a lot of effort, reduced the backlog tremendously. I was also able to bring down the corruption levels, although working very closely with my colleague who was junior to me in terms of years in the bench, but nonetheless my boss in that capacity. And I streamlined the registry, more particularly the succession registry. Bungoma has a lot of succession matters, and the registry was ranking high in terms of corruption. I was able to lower that. Thereafter, I was there for 3.5 years. Thereafter, I was posted to the family division, a very busy division in the hierarchy of divisions in Nairobi, and I assisted the presiding judge, and together with colleagues there, we reduced the levels of backlog. I was there for again 3.5 years when I was then posted to Garissa, where I'm currently the presiding judge. I must say that in Garissa, the workload is not heavy, therefore I'm able to engage in a lot of other activities that has brought the judiciary closer to Mwananchi in terms of accessibility and engaging, and there we have a very robust CUC that has been able to make a lot of strides within the community. Thank you, Honorable Chief Justice.
Yes, now in the Court of Appeal, you'll be engaging with some statutes. You can tell us which ones are going to be relevant for your work, and in particular, the main shift that you're going to make as a judge of the High Court when you become the judge of the Court of Appeal?
Thank you, Honorable Chief Justice. I will start with the Constitution as the primary document. Then there is the the Appellate Jurisdiction Act, the Court of Appeal Organization and Administrative Act. They are the rules of the Court of Appeal. I also want to believe that the Election Act is one of the acts during this season, and the election rules are also going to be relevant. Thank you.
Thank you, Honorable CJ. Honorable Judge, I've seen your CV, your bio, and all the documents. My questions are in respect of, will touch on leadership. And I would like to request to ask you whether you describe yourself as a visionary leader, and what does a visionary leader, what characteristics what does a visionary leader have? What characteristics? That's one question I would like to ask you.
Thank you, my Lord Judge Ibrahim. I would describe myself indeed as a visionary leader. My CV speaks volumes of that. And the reason why I believe that I'm a visionary leader is because I am transformative, which is an attribute of a visionary leader. I am bold and courageous. I am a team player in the places that I have been able to serve. I also am able to motivate and nurture the people that work with me and under me. And I am a hard worker, and I am able to focus so that I can achieve certain goals that I earmark. So I believe that I am indeed a visionary leader, and with those attributes I want to believe that I will add value if the Commission allows me the privilege to serve in the Court of Appeal. My hard work and my vision will certainly add value to the other visionary judges that serve in that court. Thank you.
Thank you. It is said there's a writer called Warren Bennis. He said leadership is the capacity to translate vision into reality. So thank you for those answers. Regarding another value or values, what are the responsibilities, obligations of a leader in terms of the constitutional values of integrity?
Come again, my Lord, I missed out on that.
Okay, I was saying, I'm asking you a question, that what are the responsibilities and or obligations of a leader in terms of the constitutional values of integrity?
Thank you, my Lord. I believe the responsibility of a leader under that requirement is first and foremost to lead by example, and in all the actions of such a leader, both in private and in public, should be above board. An open leader who is able to command the respect of the peers and those working alongside this particular leader, and to inculcate those values where there is a miss amongst the people working with a leader.
Okay, thank you. Integrity is not only about financial honesty or about not being corrupt.
My Lord, I think integrity does encompass lack of corruption, and that's why I said you have to be above board, that you must lead a life of a clean life where there is no perception or no corruption at all, as you're open and accountable to people, both in public and private life.
Thank you. I heard you mention that you are a transformative leader. What do you understand by that term, transformative leadership? Of course, we have talked of the vision, and as you are aware, the vision of our Chief Justice, and which he launched with all the aspirations in the next term, the judiciary's social transformation through access to justice. And these are embedded in the Constitution and other legislation. What contribution can you say you have made to advance access to justice for the vulnerable members of society in the northeastern province, as you are based in Garissa? Garissa, which is in northeastern, historically has been a place where formerly it was called NFD. There was an area which had historical challenges from the days of the emergency, and you know the history of that area. The area has been underprivileged, and then there was, of course, the issue of the basic rights were not really enjoyed, and we hope that things are changing. So, could you tell us what changes you have brought to Garissa and Northeastern?
Thank you, my lord. I think your observation is completely correct. I must say that I have not seen the kind of poverty I have witnessed in northern Kenya, and like you, I'm hopeful that with good leadership, the people of Northeastern are going to uplift their standards of living. In terms of what I have done in transforming, number one, my lord, I believe a transformative leader is a leader who brings change and who transforms, or who adds value to what they find. My lord, what I have done, as I indicated before, the volume of work in Garissa is not as heavy. I can't compare it with the other 3 stations that I have served, that is Bungoma or even Nairobi or Kisumu. So I have a bit of time with me, and I have been able to work closely with the CUC. I have attended most of their activities where they try to take justice to the people. I have attended sessions. I have been able to sit with the sheikhs, and in one of the documents that I've passed to the commission is a narrative by the secretary of the CUC that for the first time a senior legal officer was able to sit and interact with the sheikhs. And I did this for one reason, my lord. The rate of sexual violence in Northeastern is quite high. The rate of illiteracy amongst the girls is very high. And FGM is a subject that is never discussed openly. It's discussed in hushed tones. And the agenda of the government is to eradicate the vice. However, it is something that people fear to discuss. And out of courage, when I sat with the sheikhs, I brought it up because it has not only traditional connotation, but it also has a religious connotation. And we had an open discussion with them, and it is something that I am passionate about, and I have approached the FGM Council to see whether there can be a discourse amongst the religious leaders in Kenya together with the sheikhs in Northeastern, so that they can be influenced in trying to help the citizens of that area, the northern eastern, to do away, because it is a harmful practice and it has no religious connotation if analyzed properly. So I have spent quite a bit of time, and since I supervise the courts also in Mandera and Wajir, whenever I have visited during my tour of visit, I go to schools where I speak to the young people to try and motivate them, and especially the girls, because I think it is good for them to be motivated once in a while. So I am doing what I can in the region, my Lord, and I must tell you that I'm impressed because of the reception that I have received from Northeastern.
Thank you very much, Judge. That's all for now.
Thank you.
Thank you very much. Milady, just following up from my brother, the Honorable Mr. Justice Ibrahim. You've outlined the work you have done, especially now in Garissa, in advancing your social transformative agenda. Milady, have you had occasion to express this in any judgment or in any pronouncement as a court in terms of that transformation as contemplated by the Constitution?
Thank you, my Lord. Indeed, the judge speaks through judgment. I have had occasion, in the set of judgments that I've placed before the commissioner, there's one that deals with the issue of maternal health, where a lady was mistreated while giving birth at the referral hospital in Garissa, and I was called upon to make a pronouncement. And I have done quite a bit. There's one on rape as well that is in the bundle. So every time I have an occasion where a matter that deals with the issue of social justice comes before me, depending on the facts and evidence, I apply the law appropriately.
Thank you, Milady. Now, just moving to another aspect, in your view, Your Ladyship, does the 2010 Constitution permit or encourage judicial activism or liberal judicial philosophy? And you might want to respond in the context of Article 259, which provides in sub-article 1 that the Constitution should be interpreted in a manner that, quote, permits the development of law, and in sub-article 3 it should be interpreted that, quote, the law is always speaking, unquote. And when you've done that, please relate it to the doctrine of stare decisis and whether this has any place in the liberal judicial policy of a court.
Thank you, my Lord, for that question. Having been involved in the initial drafting of the Constitution, and to say that quite a bit of what we have today emanated from the Constitution, the National Constitutional Conference, I must say that the Constitution 2010 is transformative in itself, and in Article 259 it tells us how it ought to be interpreted. So it is a very robust document. There was heavy presence of civil society, probably that informs why they are underpinning connotations of activism within the Constitution itself. So what I would say is that when applying and interpreting the Constitution, one cannot afford to give it a conservative approach. It has to be a liberal approach to be able to live the values and principles of the Constitution. On my part, I would want to say that when I interpret matters that come before me and reference is made to the Constitution, I try to be liberal in my interpretation, but I do not go overboard. I think activism has its place, but one has to be guarded, because when you go to the extreme, then you I think you may quite easily step on other arms of government. So for me, I think one has to be guarded as much as one tries to interpret the Constitution with a liberal approach. And indeed, the Constitution is a living document because it has to be interpreted bearing in mind the circumstances of our country.
And where does precedent lie in that interpretation? If for instance you find in your liberal interpretation you're going against precedent, what does one do? What would you do?
In a situation like that, my lord, I would as much as possible rely on the doctrine of stare decisis, but inevitably with the incoming of the new constitution there are matters that are off the way and may not sit well with the provisions of the current constitution, and inevitably I would need to consider the provisions of the constitution.
And finally, Chair, with your permission, Judge, it's often been said that the courts have been engaging in judicial legislation. What are your views of that accusation, and would you agree with it?
Thank you, my lord. I agree with that entirely. And I would want to say that with the incoming of the Constitution 2010, the judiciary is called upon to make certain decisions. For example, matters of judicial review, and also on the issue of violation of human rights and fundamental rights. And there are times that the judiciary is called upon to interpret certain statutes vis-a-vis the Constitution, and we have to make declarations that are inevitable in the discharge of the interpretation of the Constitution. So it is inevitable time and again, but as I said before, as one is being liberal in interpreting the Constitution, one has to be guarded, because the primary work of Parliament is to legislate. Ours is to apply, but again we are given that mandate by the Constitution to safeguard and to ensure that other laws are consistent with the grand norm. Thank you.
Thank you very much. That's all from me, Honourable Chair.
Thank you, Honorable CJ. Judge, let us discuss the case of Bungoma, the case of the lady by the name Ogwen.
Yes.
You can remember?
Yes, it rings a bell. Thank you.
This is the lady who had been forced to give birth on the floor of the Bungoma hospital. And the matter was reported on KTN. And the suit was filed before you against the Bungoma County government and the Ministry of Health. According to you, what was the role of the county government and what was the role of the national government in this mistreatment and degrading circumstances that was exposed to the lady?
Thank you, my lord. I want to believe that in the provision of health, state here, I would read it to be the national government. It has an obligation to ensure that Kenyans enjoy high standards of health facilities, including maternal health. So when the national government was included as a respondent in my finding, I was of the view that it did not facilitate their referral hospital with the necessary facilities, because from the evidence it appeared that the county government did not have facilities for every woman who attended that hospital. As for the county government, it did not have any policies in relation to maternal health, and the defense that was put forward was lack of resources, and I found that both were culpable for failing to avail resources that would have enabled a safe maternal health to the litigant.
Okay. As per our Constitution and the Devolution Act, health is one of the items that has been devolved. So, what is the role of the national government in this circumstance of this case?
My Lord, I want to believe that the state, read government, has the primary obligation to ensure that every citizen enjoys the highest standard of health. The county government receives resources from Treasury once the resources have been devolved to them. So as much as one would blame the county government for failing to avail those resources and having policies, the primary duty and obligation to ensure that we all enjoy the rights in the Constitution falls upon the state.
Okay. Again, in your decision, you termed the omission and the acts of the county government and the national government as inexcusable. You also stated that the lady was exposed to cruelty, inhuman treatment, degrading treatment, and her dignity was violated. I hope that's a reflection of what you said.
Absolutely, my Lord.
Yes. Nonetheless, you awarded her damages of 2.5 million. Why?
My Lord, let me say this. When your right is violated, when a woman gives birth on the floor of a hospital where all and sundry are watching, where people take pictures of such a situation, it is not possible to equate that to any monetary value. So in my assessment, my Lord, I felt that she needed to be compensated for the indignified manner that she was treated at the hospital, and I thought a reasonable paltry amount that could nurse that injury was 2.5 million. There was nothing scientific about it. I used common sense and my judgment as a judicial officer.
Okay, I agree there is nothing scientific or mathematical about award of damages, but in the circumstances of this lady, do you feel that the award you gave was too low?
It is very possible, my Lord, that it was low, but again, we are talking about public resources here, and I have said, as I have said again, no amount of money would have compensated her for the ill treatment. So it was a sum that I felt would be able to assist her overcome the tragedy.
Okay, let's go to this case of which you also dealt with, which was the issue of participation and the extent of a victim in a criminal trial. In your view, what is the role of a victim in a criminal trial, and how far can the court go in allowing a victim, for example, to participate in a criminal proceedings which is solely within the jurisdiction of another arm of government, another arm, let me say.
Thank you, my lord. I must say that my decision went up to the Supreme Court, and I was vindicated in the sense that the Supreme Court upheld the decision that I made as a trial court. In that matter, my lord, what happened is that the counsel for the victim requested for leave to be able to cross-examine some of the witnesses. And considering the provision of the Constitution 2010 and the Victim Protection Act, I was of the view that in the current development of law, a victim cannot be a passive spectator in a trial, that the victim may come in to assist the court in order to arrive at a justifiable decision. And in my ruling, I indicated that the counsel representing the family of the victim would only come in at upon request and determination by a court at the point of submission as to whether there is a case to answer, and at the close of the case, and as and when an application is made and the court determines whether it is right for the victim's counsel to get involved. Otherwise, the victim's counsel does not conduct the prosecution parallel to the office of the ODPP, because that's they are preserved under the law.
Okay, let's go to election matters. There are two controversies around Section 85A of the Election Act. Please tell us what are the controversies about in respect of election appeals before the Court of Appeal.
That's a tricky question, my lord, but I think the controversy that I'm aware of is whether interlocutory applications should be allowed during the pendency of the trial in the High Court. I think that's the one that immediately comes to my mind, and also whether the matters in the High Court and the Court of Appeal are sequential, or do they run consecutively?
Okay, my last question. What is an offense of strict liability in criminal law?
Thank you, my lord. The offense of strict liability is where an offender does not need to prove mens rea. For example, if one is caught driving a vehicle without a license, your intentions are not important, because the mere act of driving without a license is in itself criminal, irrespective of whether your intention was to carry, but you probably forgot in the suit that you wore yesterday. So I think that explains the concept of strict liability.
Thank you very much, Judge. Thank you, Honorable CJ. I'm through.
Thank you.
Thank you, Chair, and good afternoon. I just want to ask you two questions. First of all, I've read your judgments. They cover the breadth of law, and I note that there were two groundbreaking decisions. The one you did in Bungoma that has actually been praised on the continent as recognizing health rights, and the one on victims' rights. But I want just to take you to another area of law, because when you go to the Court of Appeal, you will deal with all manner of cases. So what do you understand by constructive dismissal in employment?
My Lord, I must confess that I do not know much about labor law for now, but I can assure you, as a student of law, as and when I am confronted with an issue of law, I will know where to find it. But constructive dismissal without pretending to know too much about that concept, I think what comes to my mind is that it is a dismissal that is not necessarily direct.
Okay, thank you for that. So let's go to another area, probably which is closer to home. What are overriding interests in land? What are overriding interests in land?
Thank you, my Lord. Overriding interests, I would consider probably a charge or an interest that an institution like KPLC would have over one's land, where they have to pass some of their necessary wiring and so on.
And so if a charge is an overriding interest, what are the registrable interests then?
A charge would be a registrable interest, my Lord.
So what is an overriding interest if a charge is a registrable interest?
I think that's...
or put it another way,
yes.
An overriding interest is an interest that is not registrable, but nevertheless it binds the land.
That is so, my Lord.
Yes.
Yes.
So now I want to go to the next stage. You've dealt with matrimonial, I can see matrimonial property cases you have dealt with. Is a spousal interest an overriding interest?
Yes, that would be, my Lord, certainly. A spousal interest that is not on title would be an overriding interest.
Okay, thank you very much.
Thank you, my Lord.
Okay, Judge, I'll ask you about 4 questions. And the first one relates to the issue of collegiality, because this is a court that is going to be collegial. And I'll tell you the concern I have, because we represent lawyers, and one consistent complaint that they have is about your temperament. Dealing with the lawyers is a common thread. Even as we are interviewing you here, they are still sending me messages. I don't know what has mainly been the challenge in your dealing when it comes to this constant accusation about your temperament.
Thank you, Commissioner. It takes me by surprise. Maybe it's something that I would need to reflect, because my demeanor is normally of a very calm person, and I have dealt with many of the commissioners here. I do not know, I don't want to judge myself, but I'll throw it to them to be able to reflect on that, whether I'm temperamental. What I know is that I'm forthright. I will not coach something in flowery language. I am straightforward, forthright, and I would speak it out. I am also I'm also a firm person, and in my dealings in court, I am firm when it comes to certain issues. And it has worked quite well, especially in stations where the workload is high, and I am able to push for hearing of matters. So I think it's a perception that doesn't describe me. But when you say it's a persistent complaint, it takes me aback, and it's something that maybe I will reflect. And although I don't have too many friends who are lawyers by virtue of my work, it's something that I would want to understand, because that is certainly not me.
You see, the reason I'm saying that, Judge,
yes,
it is not just the complaint they bring to us as the representatives, it's even also reflected also in your report here. they seem to be too much. And you take an example of like
Yes.
Kisumu, even at some point in time there was a demonstration.
No, never. There was never a demonstration in Kisumu. I am not aware of that at all. In fact, in my write-ups that I've put in my list of testimonies, and I would invite you kindly to look at it, you will see that as late as 2009, when I was a judge in Kisumu, they are very good recommendations, because I've come to this commission a few times, and I have kept the recommendations that I got from Western Law Society.
Have you ever put
about
in jail?
Pardon?
Have you ever put in an advocate in jail together with a client?
A client, I'm not aware, but I'm aware of a lawyer, and I didn't put him in jail. What happened is that he was extremely rude to the court, and I fined him 15,000 shillings, which really was not punitive in my mind, and he paid. The idea was not to really punish him as such, because I knew he could afford the 15,000 shillings, but just to uphold the dignity of the court. That was 10 years down the line.
Yeah,
I can assure you that over the years I have grown in my progression as a judge, and if it were to happen today, I would not do that. So I would want us to look at me having progressed as a junior judge to what I am today. If I reflect, I probably would not have fined him. I would have let go.
Which station was that?
That was Kisumu that I'm
Absolutely.
talking
And
about.
That's the one I'm saying. After
Yes,
that,
yes.
There was a demonstration.
There was no demonstration that I'm aware of. In fact, we had a very vibrant bar bench when I was there, and the recommendation that I got in that year from Law Society and Senior Counsel will tell you that I had a very good rapport with the advocates. It was a one-off, and regrettably it happened.
Now, the other issue that they complain about so much, the issue of this delay in judgments.
I do not have any delayed judgment, Commissioner. Not at all, except one that I delivered last week, and I can explain what it was. A matter that was 40 years at the time when it came before me in Nairobi, and this was just before my transfer to Garissa. And I kept coming back at the request of the presiding judge, because I can tell you no judge wants to look at a file that is 40 years. In fact, my lady, the Chief Justice, dealt with it in 2003. And I kept coming to hear the matter. And I eventually last week delivered the judgment. As we speak today, the next judgment stroke rulings I have are earmarked for this Thursday. I do not have any delayed judgments.
Yeah, there's some.
Yes.
Well, unfortunately, of course, it's difficult for you to remember.
No. I'll be glad if you could draw the same to my attention, Commissioner.
And course 48 of 1982.
408.
408 of 1982.
Yeah, that's the one. Yes.
Yeah, which has been pending since 27th of January 2022. Milimani Matrimonial Court 68 of 2015. Kisumu High Court Criminal Appeal 176 of 2019. Milimani P&A 2581 of 2011.
Yes.
Milimani P&A 408 of 1982.
That's the same one, Commissioner.
Sorry. Yeah,
yes.
Yeah. Then Milimani P&A 1506 of 1997. You can see they are old matters. I'm just speaking from the information, and from this, that the judgments take too long, which of course causes, problems too, because most of these are succession matters. In fact, one of them was where even the party was claiming, they actually, I think I even forwarded it to CRJ sometimes back, was where the parties in the matter could not even access the funds of the estate, and the child even at some point had to be thrown out of school because of lack of the school fees. So you can see, the injustice that it causes to the family because of the delay in resolution of the matter.
Thank you.
For your information, I don't go to court myself. I'm just quoting to you from the lawyers themselves.
Yes. Thank you, Commissioner. You realize that all these matters that you have mentioned are pretty old matters, that when I came to the family division, they were already ongoing. Most of them would come to me at the request of the presiding judge to come and finish them in Nairobi, for the main reason that it is difficult. For example, every time a judge is transferred, to get another judge to handle the matter. The Nairobi family matters are normally in volumes. Volume 1, 2, and 3. So it's very difficult. So I'll be called upon to come and assist the family division in Nairobi, and I would carry these files to work on them alongside my work in Garissa. And I have tried very hard not to refuse, because I could have requested them to use Section 200 to have the matters done by judges in Nairobi, but out of sheer commitment, I would accept the files, and I'm required to finish these matters alongside my own work in Garissa. So I have worked very hard, and as we speak today, I do not have all these matters. I don't know when the report came to you, but a lot of them I finished before the April vacation, except 408, the 40-year-old matter that I needed a lot of time to sit and be able to understand. Kisumu, I must tell you, I am not aware. I was in Kisumu 10 years ago. So 2019, I was not in Kisumu. I left Kisumu, I think, 2013. And in Bungoma, I do not have any pending matters. So the Kisumu one, I think a bit of investigation will have to be done. In 2019, I was in Nairobi.
Now, let's move to the next thing.
Yes,
now,
thank you.
Going to the Court of Appeal, you see, the reason why I'm asking these questions is that because there are also delays there, granted, but we would want somebody who's ready to hit the ground running.
Yes.
In the sense that you step in there, you're able to work with your colleagues and to ensure that matters are concluded expeditiously. Because it's not just a question of pumping in numbers to the Court of Appeal, it's numbers that we'll be able to deliver. Now, what steps would you take now that you're hearing, I'm giving you a feedback of all these issues that have been raised? What steps would you take to ensure that once you are indeed there, that you're able to live to the expectation, particularly of ensuring that those things don't become again another problem that is brought to the Court of Appeal, particularly the issue of temperament and also expediting the matters?
Commissioner, I humbly request that the Commission, because I have worked with a number of commissioners here, including the Honorable the Attorney General, the Chief Justice, the Supreme Court Judge, Honorable Judge Majanja, and Warsame, that this commission character. Because I am not temperamental. I am a person who is able to work under extreme pressure. I am a hard worker. My history in the Constitution of Kenya Review Commission speaks for itself, and I humbly beg that a reflection of that is taken. Being judged as being temperamental, I think is unfair. I don't want to cast aspersion on anybody, because people have different perceptions, and it is something that I am willing to reflect as an individual, but I do not think that that is a fair assessment of my character. I am a calm person, I am down to earth, and I am extremely humble as an individual and as a judge. As far as the work ethics are concerned, I'm a hard worker. The files that you have mentioned, as I indicated to you, were a request by the division in Nairobi.
No, just leave that for a moment.
Yes.
I'm now addressing now.
Yes, thank you very much. But I'm trying to relate the two.
Yeah.
That I have my work in Garissa, which I'm up to date, and I have this work from Nairobi that I am trying to assist, and I have finished. Going forward to the Court of Appeal, I work extremely hard. I am able to churn out work assigned to me with reasonable speed, and I believe that I have good working ethics that I would take to the Court of Appeal. I do not fear work, and I am a person who puts my work as a judge as first and foremost in my life. I actually sometimes cannot balance between my private life and my work as a judge because I live my judgeship. Okay. So I think I will be able to add value if given a chance to serve in the Court of Appeal.
Okay. So one final question. Now this legal, purely legal. We leave, about, the issues you addressed about the personality.
Yes.
There is this recent decision that has revolved around section 66(1) of the Marriage Act. It seems to be a contentious area, and to be specific, because I don't expect you to remember probably offhand about the section, it talks about the period within which you cannot put in a petition for a divorce in a civil marriages, where it says that you can't do it within within 3 years. Now, and the petition was brought in Malindi, where the contention was that this is discriminatory in the sense that the same provision is not there in respect to the other forms of marriages. And the judge went ahead and declared that section unconstitutional. Then the matter went to the Court of Appeal, and now a decision has been rendered, which has said that the section is not unconstitutional, but the proportionality, it has said that what it has recommended is that there be a period of 3 years within which Parliament can go ahead and look at the section again and align it with the rules relating to that, to the proceedings of a dissolution of marriage. I don't know that you're familiar with the. Before I go to the next question.
Yes and no. I think I read it in the press. Yes, but I am familiar with the 3 years. That is different in regard to statutory marriage as compared to the other forms of marriage.
So what is your view about it from your basic information and based on the decision made by the judge in Malindi?
I think there has to be consistency in the first place, because if the other types of marriages enjoy 1 year or no limitation, that it is certainly discriminatory to get a law that does not allow people who contract statutory marriages immediate access to courts or within an equal period of time to have their marriages dissolved. So I think there needs to be consistency because the Constitution has emphasized the need for equality, and I think all marriages should be treated equal since they are all recognizable under the law.
Yeah. But you see now the Court of Appeal has said it's not discriminatory. They've actually found that to be wrong on the part of the judge to have declared it discriminatory, but said instead that particular section falls short of the proportionality test, in the sense that people may not live together, may agree that they are not compatible and may not want to live together for 3 years, but the issue of now proportionality, and consequently it's a question of now tweaking the act, the section, but not declaring it discriminatory. I don't know what is your view about it, so that if you are to be in the Court of Appeal, what would be the position that you would take regarding it if a matter like that fell in your, and the court actually went ahead and said don't remove the section for now, give 3-year period time for legislature to sort out that mess, which means in effect the section continues being applicable for now.
Thank you, Commissioner. I will be discussing this from the abstract. I do not know the rationale of the Court of Appeal. I'm sure eminent judges addressed their mind to this. But speaking from the abstract, I think that section appears to discriminate one section of Kenyans. Secondly, they were probably guarding against the complaint that the judiciary is interfering with the work of other arms of government, and they have pushed it to Parliament to look at it. But I think there is an acknowledgement on their part that there's a problem, and hence the 3 years given to Parliament to relook the issue. I think there is a quiet acknowledgement from what you have said that section of the law is problematic. I would probably have given a dissenting view, but again subject to the details and the facts of the case. Thank you very much.
Thank you, Judge. I've looked through your sample writings, and I'm happy that one of the ones you have highlighted, the Bungoma matter, I participated in the reviewing of the draft pleadings. So I might say you are quite bold when it comes to deciding the so-called technical and difficult matters. I just want, if you don't mind, when you say mixed heritage, I would want to know more about it, if you don't mind, for the rest of Kenyans.
Thank you. I do not mind indeed, because it's good for us to be proud of our diversity as Kenyans. My late father was an immigrant from the Comoro Islands. I get about emotional when I speak about him.
If you're not okay, yeah, you can stop.
No. I'm okay. It's nothing to do with the heritage. Just that it takes time when you lose a parent. So my father was an immigrant from the Comoro Islands. He came for greener pastures in Kenya in the 50s. My mother was born of a Goan mother, and a father that we never met that was from the mountain. It is suspected that he was from Kirinyaga, and that makes it difficult for me to then place myself anywhere, and that's why the answer I had, that I belong to the other, the 43rd tribe of Kenya. My mother was Kenyan, and I think under the 1963 constitution, born, bred in Kenya, so I'm Kenyan.
Okay, thanks. I just needed that clarification, because for me, my mom is, I thought I should also say mixed. My mom is from the Terek community, and my dad is from the Bunyore community, so I thought I can also refer myself as mixed heritage, but yours is different.
Yeah, I think mine is a bit complicated.
yes.
Thank you.
Yeah, so Judge, there is this issue that keeps popping up, the Sarah Mbondo matter. When was it resolved?
The Sarah Mbondo matter was resolved at the level of vetting.
So what year, please, if you don't mind?
Pardon?
What year was it resolved?
The vetting, I was revetted, I think, in 2015.
So you resolved it in 2015?
It was resolved before that. I think it was resolved in 2013. But my revetting was in 2015. I think that is when the issue was brought to a closure.
Okay, thank you. I've also seen among the decisions you have highlighted here, the sample writing is with regards to division of matrimonial property. there is a tendency at the High Court, and this brings to my, I think everyone now knows I keep speaking about the inconsistency when it comes to decisions from High Court and other superior courts. There is a tendency of judges to over-rely on direct monetary contribution as opposed to indirect monetary contribution. What do you have to say about that?
I think there are very many judgments from the High Court and the Court of Appeal where emphasis has been placed on non-monetary contribution by a woman. I think on my part, I would balance. I would look at the attributes and the contribution that a woman has brought on the table during acquisition of matrimonial property, because the non-monetary contribution by a woman cannot be counted in terms of monetary terms. And I think the law is very clear now that you must consider other contribution that a spouse makes in making the other spouse successful and wealthy to be able to have resources to purchase property. And I must say this, Commissioner, I think these days it could be either way. And I must share this with you that before I joined the bench, I sat with counsels who were facilitating and explaining to us about the law. And I kept saying, this is, you must remember, they are very hard-working women coming up and very strong economically. So it can go either way. So contribution by spouse that is not monetary is not necessarily a women's affair. It could go either way, and it must be, as a matter of necessity, considered.
Okay. And lastly, just a general comment. I didn't know you're the one who handled the Lentrix Waswa matter.
Yes, and, I did.
Thanks to you, we have the Supreme Court give guidelines on victim participation in criminal matters.
Thank you, Commissioner.
Thank you, and all the best.
Thank you.
Honorable Chief Justice, thank you.
Thank you, Madam Chair. Honorable Judge, just a few questions or discussion that you need to hold. And as we do that, I must also confess that you actually doing the constitutional review in 2005, and you did a good job. I can witness to that fact. But now I want you to wear the hat of a state officer and a public officer for that matter. And I want also to focus on Article 232, the principles of public officers, and focus that in Garissa, where you're working, and share with this commission 2 of those principles that you are promoting to ensure that the people of Garissa, the ones who come to your courts, are properly served. And as they leave the court, that they are satisfied with the service that you give them. Just 2 of them.
Okay. I want to look at professionalism.
Professionalism, yes.
And integrity.
2 of them. Okay.
If I may start with the issue of integrity, as the presiding judge in Garissa, it came to my notice that the assessment that was done in Garissa in 2019 rated us at 8.33.
Okay.
Which really took me by surprise, because when you serve as a judge or an officer in a station, you can feel the vibes. For example, when I was in Bungoma, I could feel, in a sense, that we were not really corrupt-free as a court. In Garissa, I have not felt it. However, I took this very seriously, and I have addressed it with the staff.
How? Question is how?
Whenever we have our staff meetings, once a month, although it is too often, we keep discussing this issue and bringing it to their attention that we owe it to the people of Kenya to lower the perception, because it could also be a perception since I haven't felt it.
Okay, we can move on to the next because my colleague will go to the details to those areas.
All right. And then on the issue
of professionalism.
Okay, let me just also say one thing that is very important that I have noted. Unlike many other places that I have served, my staff in Garissa are predominantly from that area, and as a person, I think it brings in a bit of a problem because they are in familiar grounds, and although we need locals for purposes of translation, due to the high illiteracy levels, maybe this is a thing that the judiciary will have to consider, because I think familiarity has its own issue. Secondly, there's the issue of officers serving for as long as 8 and 6 years in one place. I think that's problematic, and the CRJ is here. She will probably attest to the fact that I have discussed this with her office, and I think it's work in progress. So that is the contribution that I partly.
Okay, what do you about professionalism?
Professionalism, I must say that, and with a lot of due respect to my predecessors, that I found Garissa without any systems. And I don't know whether it's the weather, but people are very casual. My first remark in the first day I visited the court was from a senior clerk who told me, Judge, hapa utazoea tufanyi kazi afternoon. And I had to tell him that I'm very strict and I'll be observing, so let us not get to that. So people are casual, so I am trying to inculcate the culture of professionalism, and also trying to motivate them, just in the event that people are demotivated because we serve in a difficult area of our country. And I have been able to, last year we gave out certificates. That was my idea, to staff that we thought were doing well. And I bought trophies for the High Court and the Lower Court that we give monthly to the best performing.
That's enough for me.
Thank you. Just to motivate and try to bring them up to speed.
I won't go to sanctions for the non-performance. What sanctions do you put in place for the non-performance?
We do peer review.
How often do you how often do you do the peer review?
Quite often, because although we are trying, due to the nature of work, we are trying to have our monthly meeting go to quarterly meetings, so that they are meaningful. So probably we'll be now going forward, we'll be doing this quarterly and on needs basis.
Okay. The next question I want us to discuss. You want to go to the Court of Appeal, and I pray that you go to the Court of Appeal. One of the key issues there is in terms of the partnership, the stakeholders for that court. Do you share with us at least 2 key stakeholders for the Court of Appeal, specifically Court of Appeal?
Thank you, and thank you for the good wishes. I think key stakeholders here would be the Office of the Attorney General in civil matters.
Office of the Attorney General. Next one?
The next one would be the Office of the Director of Public Prosecution.
Director of Public Prosecution. Would you share with us how you are going to promote that partnership to make sure that you work in harmony and you work for the success of the court? 2 strategies that you are going to use.
I think communication is always a very good tool of enhancing cooperation. And also timely delivery of judgments
Timely deliveries, okay.
Yes.
That is as far as the Office of the Attorney General is concerned. I want you to focus on the Office of the Director of Public Prosecution. What do you expect from that office for the court to do its work properly?
I expect proper preparation by the ODPP in their submissions, and secondly that the submissions will be filed on good time.
Okay. Thank you, Judge. Thank you, Chair.
Thank you.
Thank you, Chair. Good afternoon, Judge.
Good afternoon.
Yeah, I represent the public.
Thank you.
So my question will be around there. You see, despite transformation agenda that has been, well, the three Chief Justices have tried to bring in JTF, SJTs, touch, the members of the public are still complaining. There are a lot of concerns related to customer service generally, where things like turnaround time on payment of fines, refund of bails, rogue judicial officers, corruption, and many other ills that are still, very present in judiciary. And so I don't know why these strategies are not working. And in your view, what reforms, can even mention 2 or 3, that you think can be introduced so that judiciary can provide high quality, effective, and perhaps very efficient customer service?
Thank you very much, Commissioner. I think that's a very pertinent question. I must begin by saying that in my practice of law for 23 years, the new constitution had not come in, and there is a very big difference between now and when I practiced as a lawyer 23 years ago. There has been a lot of improvement and transformation in the judiciary, so that the blueprint by our 3 Chief Justices have not all gone in vain, but we have not reached there yet. I resonate with the complaint of the Mwananchi about the judiciary. The judiciary is a very big institution. Some of the complaints are perception and some are real. When it comes to the refund of bail, honestly, I cannot understand why there's that delay. I do not know, because I'm not very conversant with the financial happenings in the judiciary. I wouldn't know whether it is the fault of the judiciary or the funds go elsewhere, or it's simply that our people are not doing their job properly. So I think if the mistake is the mistake of the judiciary, and now that we are going to have our own fund, I think the systems have got to be put in place for this to be done. On the issue of corruption, wow, this is really a major problem. And I think a lot has been done, but there's room for improvement. But what I feel sometimes, and I don't want to criticize, because I know that a lot of thought goes into disciplinary action of personnel, but sometimes you find that, for example, a financial officer who has been found culpable, let's say in Bungoma, is transferred to Kakamega. So for me, I think that is transferring of a problem. I know the judiciary is a very good employer. The judiciary is kind, because the private sector would not do that. But maybe it is time we changed tact and do things with due process so that the employment court does not find fault because of due process. And I think we need to bring people to book, because that is probably the lesson that corrupt individuals need to go through. I know there's a lot of communication since the Honorable the Chief Justice became the head of the judiciary from our media personnel, but I think we need to do more. Human beings tend to believe what they hear, and sometimes you need to speak and pamper yourself for people to appreciate you. So I think we need to improve on our communication skills, because I think the JSC, the Chief Justice, and the leadership of the judiciary has done a tremendous job to curb corruption, but we have a long way to go.
Thank you, Judge. Thank you, Chair.
Thank you, Honorable Judge. Good afternoon, Judge.
Good afternoon, Commissioner.
Just a few questions. From your CV, you have said that you have strong interpersonal skills and also you are a keen listener. So please describe to us these skills and how you use them in a collegial court you want to join.
Thank you very much for those questions. I am very amiable. I am able to relate with people at different levels, be they my seniors, be they my juniors, irrespective of status when I'm dealing with the staff and even the ordinary mwananchi. So I think my communication skills are excellent, and I should be able to fit in a situation that is expected in the Court of Appeal. I should be able to relate very well with the colleagues who are serving in that capacity. I am a keen listener. In fact, sometimes I'm faulted for being too patient. So I have an ear to listen to the other person and to be able to appreciate their side of an argument or their side of the story, and not necessarily being swayed where I have formed an opinion.
Okay, thank you. Judge, please, okay, another description that you have been given, and you have to bear with us because this is things we can't ignore when they come to us. But you have been described as unapproachable. So I want you to demonstrate to us, Judge, that you are a team player and that you are approachable.
I want to look at it two ways. It depends on where it's coming from. Having come from the legal practice and civil society, out of choice, I don't want to say I shunned, but I kept away from a number of friends because having practiced law for 23 years, I can tell you I knew most of the senior lawyers in the country, and I knew a number of people both in high office and elsewhere. So I chose to keep away. So if you call me because you think I knew you or we knew each other, I would not entertain that. And a number of times, including my current office, I have been called by people. I think because now of the CUC interaction, our numbers are all over the place. So I would receive a call and I would be told, I am so and so, don't you remember? I was a member of the Constitutional Conference, for example, and I have this matter before you, can I see you? And I would say, no, I don't think it's appropriate. When they insist, I would say, do you mind coming with the opposite side? And then that becomes end of the story. So that has happened. And of course, then I'm not approachable in that regard. When it comes to lawyers, I think our code of conduct requires that we keep distance, and that our interactions are limited. And I can tell you that is what I live. I have lost all my lawyer friends, and I had a lot because I am avoiding a conflict of interest. Otherwise it would have been impossible both for them and for me. For example, when I served in the family division, because I was a serious family practitioner, and that division has a clique of lawyers who have been there for a long time. So I think you need to put it in context. Otherwise, I think I am approachable in the right context, and an amiable person.
Lastly, from me, Judge, I'm a researcher, so I want you to put yourself in that mode. If you are to give a random set of lawyers a questionnaire to rate you, lawyers,
yes,
your colleagues, and litigants, out of a scale of 1 to 10,
yes,
how would the lawyers rate you?
The lawyers would probably rate me at 7. I'm saying this because of what I've heard today. They'll probably rate me at 7. My colleagues, I would expect 10 out of 10 because I have no issue with anybody, and I can tell you I cut across because of the others, so my friends cut across. You will find me with people from different parts of this country. Litigants would give me 10. Because I'm a judge of the people, and I feel it.
Wow, 100%, eh?
They will give me 10, or let me be modest, they will give me 9.
Maybe 9 is more...
yeah, more realistic.
None of us is perfect.
Yes, absolutely.
So, I know I said last, but let me ask you, anything innovative, Honorable Judge, that you have done or introduced in your career that you can say this is innovative, I did it, it's working for judiciary? Can you think of one?
I wouldn't want to claim that I've been the initiator of any of the things that I have done, but when I went to Kisumu and when I was in Bungoma, I streamlined the registry dealing with succession, and I was very successful in that because I replicated what I saw happening in Nairobi, where we had a checklist, and I also insisted on having only one person dealing with those matters, because succession matters are a cash cow for registries in many courts.
Okay. Thank you, Honorable CJ. Thank you, Judge.
Thank you very much.
Thank you, Honorable CJ. Good afternoon again, my lady.
Good afternoon, Your Honor.
Before I ask you the questions I've been sitting here listening to questions my colleagues have been asking, and I've been waiting for them to ask you one very controversial question that has been dominating the discussions in this room previously. Now that no one has asked, let me take it upon myself to ask. What are your views concerning abortion and LGBTQ rights?
I actually had a premonition that I would be asked that question on my way here, and allow me not to give my personal view for one reason, that I don't know who's watching, and litigants would be afraid if they were to appear before me on these issues. So I'll base my answer professionally based on the law. The issue of abortion, if I may go back, was and is a very emotive discussion in Kenya and now worldwide with pre-life and pro-abortion proponents. In Kenya, I think our law is very progressive, if I may put it that way, and if one is to put the provisions of the Constitution in perspective. And I resonate with the feeder case that was decided, was it last year, by the High Court, where the High Court found that abortion is illegal in Kenya. However, there are instances that abortion is permissible. For example, when the health of the mother is at stake, and I liked it when the definition of health was expanded to include mental health, because it's a very difficult situation for young girls and women who have found themselves in situation where they have been abused by action of rape or defilement, and it must be very traumatizing for them, and the issue of the mental health cannot be ignored. So I think our laws capture situations that would be permissible and that take our history as a nation and our culture into perspective, so that we do not have to look to the West to ape their culture. I think it's captured very well, and I think with the decision by the Supreme Court of the United States, I must say they are learning from us. So I think we are doing very well as a nation.
Thank you.
On that.
Yes.
On LGBT, I would look at it in two perspectives. That our constitution does not allow discrimination, and therefore when dealing with them we have to be fair, irrespective of their style of life. It is their choice. However, there are limits. Marriages of same sex are outlawed. So I would say that they enjoy their fundamental rights, but to that extent, with the limitation that the law gives to them. I think it's probably we haven't gotten there as a nation. It's work in progress. So I would leave my comment to that, if you may permit me kindly.
Okay, let's not open it up to too much, because like I said earlier, it's very controversial. We can have discussions here until tomorrow. So for that, let me just leave it at that, and I'm glad we've put that one now to rest. The other question I wanted to ask you concerns performance management. It is said that what gets measured gets done. We have a mandate as an institution, and I want to hear your views whether you feel with the framework that we have in the PMMU, whether it helps us to deliver on our mandate.
Thank you very much. I think that's a very pertinent question, and when I look at it in two perspectives. First, I put myself in the shoe of the litigant and the lawyer, having been there for longer than I've been a judge. And I can tell you, when I practiced law, I felt the impunity of judicial officers. And I say this as a judge and with a lot of humility, because work was never done as we are doing it now. Judgments took long periods of time compared to now. And the measurement was inevitable, because now as judicial officers we are accountable, and it is easier for JSC or the Honorable the Chief Justice to know who performs and who does not perform, because with all the attributes of a judge, I think key is performance. The Mwananchi out there wants to see results. So I think it's a very good tool in measuring the performance of an individual, of a station, and of judiciary as a whole. And I strive as an individual to perform at optimum.
Thank you, Judge. But do you think it comprehensively addresses the issue of performance? For example, there are concerns that it only focuses on the quantitative aspect and not the qualitative aspect. Is that a concern that you share?
I think it is. Many a times I've asked myself, when I'm writing a judgment, what do I do? Do I simply give a judgment to finish? And what rings in my mind was Chief Justice Emeritus Maraga speaking to us once. He said, look, we have backlogs, stop writing theses. Okay, so I think it's a balancing act. If you have a simple issue before you, probably you do not need to spend a lot of time. An issue that is moot, you don't have to spend a lot of time. But if it's a complex issue, if it's a novel issue, then inevitably, as a judicial officer, then you owe it to yourself, you owe it to the institution, to take your time to write your judgment. So it's a balancing act. But I'm hoping with time and the facilities that we have of researchers, once judges are adequate and magistrates in all cadres and levels of the judiciary, that quality would really be the thing to look at. But right now, it's a balancing act.
Okay, thank you. Now let's move into your own performance. Look at it both qualitatively and quantitatively. Have you familiarized yourself with the success rate of your cases where appeals have been filed against your decisions?
Yes, I do.
How would you assess that?
I normally read my feedback, case back, and sometimes I go out of my way, just out of progression, and I do not have a lot of my matters being overturned.
If you had to do a percentage?
I would rate myself at 70, 80.
80%?
Yes, the ones I have seen.
Okay.
Yes.
My other question concerns your leadership skills when it comes to performance. From listening to you this afternoon, I'm satisfied, I'm convinced that you're actually a transformational leader. They say a transformational leader is usually not satisfied with the status quo. And I was quite impressed, I must say, Judge, that you have your facts on your fingertips. You know what the situation is when it comes to corruption prevalence in Garissa. You even have thought about how to address it. Now let's move to backlog. Would you give us the figures roughly, or an estimate of the backlog situation in Garissa?
I actually have no backlog. I saw the statistics, and I have been engaging Dr. Kimalu because I think a lot of his statistics are wrong, because I don't have backlog. I am doing 2022 and 2021. I have very few cases of 2018, 2019, and these would be criminal cases. The unfortunate situation in Garissa is that the Masla concept is rooted in the community. It's a very good concept, but when it comes to capital offenses, it then erodes the concept of justice, and it takes a lot to convince witnesses to come to court. The ODPP, I really push them, always have turned to the investigating officer, and I remind them that the buck stops with them. So through the CUC, we have really been able to engage with the DCIs and the OCPDs to see how this can be done, and I think the CUC is also engaging the elders, but because it also comes in cases of sexual offenses. As we speak now, yesterday I was dealing with a certificate where a lawyer has asked me to arrest my judgment due for Thursday done because in a murder, because there's masla going on. I've directed him to serve the ODPP because I am waiting to hear what the ODPP will say. So masla is deep rooted. It is not easy, especially when locals kill locals, to have witnesses. So in such situations, I may have a few cases of 2019, but I have no backlog at all because the workload is manageable, and with my experience from Bungoma and Nairobi Family Division, I am able to easily deal with my matters.
Okay, thank you, Judge. I'm wondering, listening to you, I'm wondering, because I'm looking at the report we have.
Yes.
From Depop, although you had already mentioned that there are disparities, your court productivity,
yes,
especially on merit resolution,
yes,
has been on a downward trajectory.
Yes.
She started off quite well, but it's been coming down consistently. And then I'm comparing, because you are alone, there is no question of comparing your output with your colleagues.
Yes.
So the only comparison I can make is with the national average.
Yes.
You're far way below.
Is it the one of 99% against 121?
No, I'm not using that. I'm looking at the court productivity, the summary report, yes, of your court, as compared to the general court productivity. What are the factors that you think impact on that?
Is it a recent one, or is it a 2019?
This is from July 2021 to March 2022.
All right, probably because I've looked at my rating as an individual, which is 99%, and I'm looking at the rating of my court, and my court encompasses, I believe, my staff as well.
Not really. When it comes to court productivity, when you're alone, you're rated, ideally you should be rated at 100, because you're handling all your matters.
Absolutely.
That's why I'm avoiding that.
Absolutely. I'm a bit surprised because I don't have any backlog as we speak today, none at all. And I have been coming to Nairobi to assist the family court, and when I first saw the report, I saw I was attributed for having sat in Machakos and Eldoret, and I brought it to the attention of Dr. Kimalu that I haven't at all sat in those courts. So I do not know. I want to believe
actually,
that
Judge, you are doing a good job. There's something I was looking for, but the bottom line is you're doing a good job.
Thank you.
Yes. Another question I wanted to ask is on mentorship.
Yes.
Do you have any people that you mentor that you can tell us of?
I can't specifically pinpoint, but I know, coming from the community that I come from, that I have mentored a lot of girls, and directly and indirectly, because whenever I have an instance, I have an occasion to speak to them. And in my nuclear family, I do mentor a lot because I want to give back to society. When I grew up, there was very little for me to pick from, and it is by the grace of God I am where I am. So I want to give back to society. I go back to my old school in Nairobi, and I know that I have mentored a number of them who are lawyers today and holding high office.
Okay, thank you. My last question, okay, not last, my second last question is from the reports we are getting from the ground, and that is that you are erratic in terms of communication, especially when you are not sitting. And I just wanted to hear from you whether you are aware of your obligation, especially under the PMMU, in respect to serving notice.
Absolutely, Your Honor, and it's something that I repeatedly discuss with my registry because the issue has come up before, but I want to look at it in different dimensions. Most of the lawyers who serve in Garissa are actually Nairobi lawyers, thanks to the virtual hearings. We have a very poor network in Garissa, and quite often my clerk and I have had to use our own money to be able to communicate with Nairobi because we don't have adequate resources to keep asking for money to buy data. Therefore, there is that issue of not having communication, even to let them know virtually that the court will be late for one thing or the other. That's one. Number two, having served, and I know you may have experienced this, when you serve in the outer stations, for some reason people think you're second grade, and you'll find that Kamiti Prison, for example, will deal with Nairobi first and then deal with Garissa. So having that in mind, sometimes I do my own investigations with my clerk to find out which prisons we are dealing with and who is already online. And because of the network issue where we need to use our own finances, and I'm not complaining about that, then we would go online when Kamiti, for example, or Kitui or Nairobi remand prison would be available for us. Now it is not conducive to be on and off. So if committee logs in at about 10, that is when we would start. And many times I have seen my clerk post. I don't monitor him all the time, but a few times I have seen him post, judge will start at 10 o'clock. So more often than not, it is the circumstances within the court. Otherwise, I am always seated on my desk between 8:30 and 9 a.m. waiting for a time when I will be able to serve comfortably all the parties. It is something that we could work on with the people in my registry to ensure that that communication is passed to lawyers. Otherwise, I really believe that communication is key, and it is something that I'm going to improve when I get back to the station. I hear what the lawyers are saying.
Okay, thank you very much, Judge. I wish you well.
Thank you very much.
Yes, please. Yes.
Honorable Judge, I'm looking at your Royal Society of Kenya certificate of good standing.
Yes.
Did you read it? Because it says there are no complaints against him, nor does he have in the past offending causes before the Advocate Disciplinary Tribunal.
The word him?
Yes, and
a lot of people think I'm a man.
But
Ali Aroni.
It is good to also go back and tell them to correct. Because now this one, how do we know it is you?
From the name, I suppose. But I must admit that I didn't see the him. But a lot of people refer to me as a man. I think. Yes, I do.
You can go back and tell them to correct because it doesn't look now the right record.
Thank you so much for that. I had not noted, but I'll draw it to their attention. I'll be more attentive next time. Thank you very much for that.
Yes, thank you, Honorable Commissioners, and thank you, Judge. We have had a very interactive session. We will also give you an opportunity to ask us a question if you have any.
Thank you very much, Honorable Chief Justice. I am first and foremost very grateful that I was shortlisted. I don't take this for granted. Many of us applied and many of us were qualified for the shortlisting. Secondly, thank you very much for the interaction this afternoon. I enjoyed it. And I have learned a lot, and I think I have picked on a number of issues that will go along to improve my progression as a judge and a person. I do not take for granted the shortcomings. Human is to err, and I think the bigger picture is where you accept and you're ready to learn. So I am ready to learn from the issues that have been brought to my attention and to improve my work in my station, Garissa. Thank you very much and have a good afternoon.
Thank you. On behalf of the commissioners, I also want to wish you well and wish you a very nice evening. We will get in touch with you when we complete the process.
Thank you very much.
Yes,
and have a good afternoon as well.